No, don't do the I'm trying to help my family thing with me. And let me just tell you why. Because you could have been helping your family, but you made a choice. You said, can I help my family or should I use marijuana? And your answer has always been, you're going to use marijuana. And I can tell you right now, probation wants you revoked because you haven't done anything. All you've been doing is using marijuana. That's all.
What you're about to watch is one of the most frustrating probation hearings you'll ever see. A young man stands before the judge asking for one more chance, but his own choices keep coming back to haunt him. Every answer he gives pushes this courtroom closer to a decision that could change his life forever. Watch closely, because one conversation completely changes the direction of this case.
2018 CR 12909W, State of Texas versus Alexis Daniel Sanchez. Can our parties announce for the record for the state?
Jason Garrett, Your Honor.
Defense?
Christian Vega.
All right, and are you Mr. Sanchez?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney?
Yes.
Did you understand it?
Yes.
Are you the same Alexis Daniel Sanchez who was placed on deferred adjudication in 2018 CR 12909W for the offense of tampering with evidence with intent to impair on December 7, 2018 for a period of 2 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor. Filing condition number 2, it's the first one, Your Honor. On or about the 28th day of March 2019, Door County, Texas, the defendant, Alexis Daniel Sanchez, did then and there legally use a controlled substance, namely marijuana, violation condition number 2.
How do you plead to that? True or not true?
True. Your Honor, will waive the remaining violation.
Any objections to the waivers?
No objections, Judge.
Just one moment. Did you understand by pleading true to violation of condition number 2, court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 2? Court will find violation of condition number 2 true. Is there a proposed agreement?
There's a proposed agreement, Your Honor. It
Yes.
is to deny the motion to enter adjudication of guilt, continue the individual on his deferred, extend him for 5 years. He expired in December of 2020, Your Honor, and that's hence we're asking for an additional year from today, a year and a couple months from today for that extension, Your Honor, and to comply with any and all other conditions of deferred.
That is the agreement, Judge.
All right. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Alexis Daniel Sanchez.
All right, what have you done on probation?
What have I done?
Yes.
Reports.
Have you completed anything?
I paid $1,300. I paid $1,300 of the $1,767 for my probation. I need to get community service on my GED.
Okay, so I don't have a trial court certification.
I need to fill that out, Judge.
All right, if you'll grab that for me, please. They're on the site.
Can I give you some context for the case?
Oh, sure. Let's fill it out. Using marijuana.
I get obviously it's like
Okay, I'm sorry. You're gonna need to speak up because I can't hear you.
clinical like pressure, but I get depressed, so I just try to drown out my problems with the.
Do you have a
No.
prescription for that?
No, I didn't.
So we're back to you using marijuana. How old are you?
But I believe that with it helps me in no way. It just gets me in more trouble. That I've already started to try to stop. That time I go back and then I'm like, no, I don't need it no more. So I stop.
Here's the thing. If I follow this agreement, you're going into inpatient treatment because you won't stop using marijuana.
No, I will be going there. I'm just trying to get back to my work and help my family.
No, don't do the I'm trying to help my family thing with me. And let me just tell you why. Because you could have been helping your family, but you made a choice. You said, can I help my family or should I use marijuana? And your answer has always been, you're going to use marijuana. And I can tell you right now, probation wants you revoked because you haven't done anything. All you've been doing is using marijuana. That's all you do. They try to put you in outpatient treatment, and I understand they said you couldn't sign for it because you were not 18. Then when you became 18, they still tried to put you in treatment, and you're constantly being unsuccessfully discharged, and you're constantly using marijuana. So this whole thing about I need marijuana to level me out, that's not going to be happening here. So you have a choice today. And your choice is I can revoke you and I'll give you 2 years. Or you're going to seriously do probation in this court. And seriously doing probation in this court is you not using marijuana. I don't know why people think that's legal in Texas. It is not legal in Texas. You're not allowed to use it.
Yes,
So do you want to go to prison?
Your Honor.
Then why do you behave as though you do?
As at the time I was young, and as I've grown older, I've come to realize that I need to change the things and stop being in the mindset of a kid.
Do you have children?
Your Honor.
Okay, that's a good thing. And then it shows here, from what I'm looking at, that you're unemployed.
No, employed.
Well, why didn't you tell probation you had employment?
I did tell him I had I worked at Hudson. I've been working at Hudson's Embroidery since 2019. And it's just
I think
like
the last time you reported, Judge, was before October 2020. So it's been a few years.
yeah, I still work there. I currently still.
Okay,
have a
here's the
job.
thing. I don't even know why should I follow this agreement. We haven't seen you since 2020.
Still have a job there, and it's,
No, I mean, but we haven't seen you since 2020. Why should I be following this?
How would you? Judge, I don't know how much context I can give, but
Oh, I need a lot of context because we haven't seen him since 2020. And the only thing I know about him is that he won't stop using marijuana. And obviously he prefers prison.
I think he's at a different place. I think he'd be willing to do whatever conditions are asked of him. I understand that he should have done it then. He was 17 years old without seeing discovery. He waived indictment. He entered a plea within a month of his arrest. And
Who did that?
I don't want to get into it on the record, but what I heard from him was troubling. And
Well, do we have proof of this? That he entered a plea without discovery?
that he didn't review it. And I reviewed the underlying case, Your Honor, and I don't want to get too far into it, but there was no Miranda warnings. The whole case is based on a statement. I didn't swallow it, I chewed it, as chewing marijuana. So he chewed some marijuana. He's the one that called 911 that day when his friend was evading arrest. And I understand it's still bad. He still admitted to it. It probably should have never been pled to, but it was. And he is asking for a shot at probation, Judge. And I understand he took that at 17, but I don't think he was fully aware at the age of 17 as he should have been. And as he's grown older, perhaps he forgot, perhaps he got so caught up with work, but I think he's at a different place and he's a different person now.
Just 1 second, because this is before my time on the bench.
Judge, I prepared a memo when I was approaching the state earlier. It details some of the evidence in the underlying case and the problems.
Any objection?
No objection. I viewed that earlier, Judge, as a motion to, I think,
It's a request for a term unsat, but
We're not going to put him on set.
yes, that's when I was trying to negotiate, and that's why I didn't file it. I just hand delivered it to the state, but it gives some context as to what I'm talking about and some of the underlying evidence that I reviewed when I was when I was hired on the NTR.
All right, I am looking at the judgment. And according to the judgment, the offense date was November 2nd, 2018.
I believe so, Your Honor.
And he entered a plea December 7th, 2018.
Yes, that's my understanding. And that's why it's the W is waiver of indictment.
And I see from your document that you prepared for the court, an officer says, I could type it out and then they could sign it if you want. I don't know the legality of a 14-year-old though.
His brother was in cuffs sitting next to him. He was in the car as well.
yeah, that's the whole reason.
You probably need to be quiet.
Sorry.
And we're asking you to extend, Judge, and I understand that it's phrased like Terman said because it was using it for negotiation, but we came to that agreed recommendation to the court.
All right, probation. What inpatient treatment can he be placed in? Oh, and state, you may continue to confer. I'm sorry, you're excused.
Judge, we would have to do a staff evaluation to get the most appropriate recommendation. For inpatient, though, Judge, we do have status. There aren't any pending cases or anything like that, so either status to address his alcohol, drug, or his drug dependence. And then I don't know if you want to, he says depression. I don't know if you want to have a MIC evaluation for us to dive deeper into that, to see if he needs any other help. But for status, he will need at least 1 year remaining on his probation.
All right. This court would deny the motion to alter the main conditions, extend for 3 years. There's to be a TAP evaluation in custody, follow TAP recommendations. But I'm going to want inpatient treatment of SADC to start with. Field visits 1 time per month for 3 months, a MIC evaluation. And you know what? Go ahead and refer him to felony drug court too. And there's to be proof of employment within 40 days of release. There's to be no employment as a home health care provider or with minors. How far did you go in school?
9th grade.
All right. Do you have your GED?
I could get my GED within 3 months.
So you don't have it? So what do you do at your work?
I'm the assistant for my manager, where I provide all the work orders, line up the work for for the employees at the job, handle customer service, call customers on the phone, handle emailing, and things like that. Where we do a lot of things for Bexar County, for the CPS.
All right. I'm going to do 250 hours of community service restitution. You're going to obtain your GED, or either you're going to get some sort of certification from a trade school. And once he completes that, then the community service hours will be deemed satisfied. Now, specifically, what do you do?
Specifically, I'm the manager's assistant with handling all work orders related to Hudson's embroidery. Hudson's embroidery.
Hudson's embroidery? All right. So there'll be proof of employment.
You need an address, Your Honor. It's
No. Within 40 days of release, there should be no employment as a home health care provider or with minors. Probation, is there anything else?
Judge, I would like to point out that he was assessed 80 hours of community service, and if you want the 250 in addition to that.
Yes.
Okay, and then Judge, with the extension of 3 years, that would only put him at 2023. So are you saying you want 3 years from now, or?
3 years from now. Let me see what he has left.
7 years?
Yes. Is there anything else you need from the court? Probation, is there anything else he needs?
No, Judge.
All right, so I want you to hear me and hear me clearly. I wasn't the person who placed you on probation. This is before my time.
yes, ma'am.
In this court, marijuana is not allowed because guess what? It's illegal and you're not supposed to be committing any new offenses. From here on out, everything that you do, you have choices to make.
Yes, sir.
You know, is marijuana worth potentially going to prison for 10 years? Well, people say no, but you're acting like it is.
Change my life, so I have goals I want to accomplish and things I want to do. And
I cannot hear a word you're saying.
I have goals I want to accomplish and things I want to do with my life, and that's holding me back from doing that. Like my main focus right now is just to continue my work, to go to the gym and join the church so I can better my life and find a community where I'm able to think positively and not continue to fall back into the same places I've fallen before.
All right, if you're back here, that's what you're looking at. Do you understand? All right, thank you. What have we discovered?
Your Honor, so as the court recalls, last time the CEO of Barcom was here,
Yes.
said he would get the information. I hadn't heard from him all week until this morning, and I haven't heard from him, I'm sorry, at all. And neither is the state. So I made a phone call before court this morning to see what's up, if he was going to appear. He's unavailable, according to his office manager, Lisa Martinez, who I spoke with this morning. She said her understanding was that he needed more time. And my problem is he, I believe, should have communicated that to either myself, the state, or the court.
Mhm.
I'll just remind the court that this is month 7 that we've been trying to get a okay.
I'm aware, my mind is still trapped, but I'm aware of what he said. He said that if he was able to get the information, he would let us know that he received the information. If he could not receive the information, he would let us know. And it appears that he has not adequately communicated.
No, Your Honor. And I did call them, and all that she said was he needed more time. She didn't tell me why, what progress he'd made, or how much time that he needed. And it leaves us in kind of limbo, in my opinion. I was going to suggest, I know the court's here next week, is that we reset this for Monday, and I don't have him, I don't know what remedy to.
No. Have him subpoenaed here for Monday.
Okay. Now, I don't know if I can get a subpoena to him in time, but I believe he's still under subpoena, Your Honor.
Well, if you pick up the phone and call them and tell them that he needs to be here on Monday,
Judge.
and he's under subpoena.
I will do that, Judge. Okay, I think that's the best remedy. And Your Honor, we also have one other brief issue I want to bring up to the court. And the court gave us permission last time that you'd be open to hearing his motion on bond. Mr. Sanchez, I did actually file this motion back in August. Your Honor, the only reason I didn't approach the court prior to this is because there was a blue warrant. That has been resolved. And so this motion to set bond is before you'd ask you to consider setting a bond for Mr. Sanchez. I will say that I did discuss this with him, and I can put him under oath if the court needs it, but he is indigent, obviously. He's spoken to his mother about finances. If the court were to set a bond at $10,000, he could post that bond. I know he's expressed an interest in hiring private counsel. In light of the fact that and this is not a speedy trial motion, and I'm not really trying to say the court is obligated to do anything because of this, but I just want to remind the court, what the court already knows, is that for the last 7 months, he has sat in jail waiting for an answer to a question which I've been practicing almost 30 years, Judge, and the answer to this question, I could go to Circle K on a robbery and ask the manager for these sort of answers and get them in a week. And so I'd ask the court, if the court feels that's a low bond, to consider what's been going on in light of that.
I didn't want to interrupt.
Oh, okay.
So we have an update on the video issue.
It does appear to answer most of the questions, Your Honor.
All right, so we can go on the record. We're going to go on the record in 2022 CR 10642, State of Texas versus Jose Sanchez. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense.
Eric Baker for the defendant, Your Honor.
All right, and are you Mr. Sanchez?
Yes, ma'am.
All right, so we were discussing an issue with regards to this video, and it appears that the witness who was here at the last setting has emailed information about the video and whether or not it even exists, the video audio. So have both parties had a chance to review the email, state,
Yes, Your Honor.
defense?
Yes, Your Honor.
All right, so any objections to the court reviewing that?
No, not at all, Judge.
All right, so from the court's review of the email, it appears that the video or audio is no longer in existence, as it is overwritten every 28 days. And they're saying that the offense date is alleged to be March 28, 2022. Is that correct?
Yes, ma'am.
And the request for the audio or video was June 22nd, 2023. Is that correct?
Yes, Your Honor.
All right. And Mr. Sanchez, the fact that the request date from your attorney was June 22nd, 2023, that is not because your attorney was asleep at the wheel or anything of that nature. It's your attorney can only make requests for certain things when they are actually your attorney. So if he was not your attorney within that 28 days, there's nothing he could have done to preserve the video audio. You understand?
He was assigned on March or April 4th, I think. April 4th, 2022. According to the event log display.
Well, Your Honor, I mean, that I probably didn't even review his file, get discovery, you know, and so, I don't think the request date is important, Judge, but the obligation to turn over discovery, such as statements of defendant, is not really triggered by a defense request. The defense request was triggered when it was brought to my attention that the discovery the state turned over did not include that, which is part of their obligation. In other words, I shouldn't have to request it. It's their obligation to provide that along with the other body cam videos, which they did. The reason I requested is because after reviewing all that and talking to my client, he brought up to me, not until June 2023, that there may be other video. So I immediately submitted a request informally to Mr. Wilkins.
All right. So with regards to the instruction for the purge, as they wanted me to refer to the purge of the audio video, you can file whatever motions you deem necessary and the court will hear that.
Of course, Judge.
Right. But I'm assuming you all are going to request a jury trial. Is that correct?
Your Honor, can I confer with my client before we come back on that issue and then on his bond issue? Because I want to make sure that's what he wants to do.
All right. If y'all will confer, and I'll take up another matter and then we'll come back. All right. You're welcome. All right. So where are we on this? Are we coming back on the 18th?
I'm sure, Judge. I wonder if it's all weird.
So are we coming back on the 18th?
No, Judge, I don't think we need to do that. It was just for the discovery. I think he's rejected all offers and we just need to set for jury trial, but I would like to be heard on his bond.
All right. So Norma, how long do you expect the jury trial to last?
A day, Judge.
It is a short 2 minutes.
All right. Norma, if I can get a jury trial date, it'll be 1 day. So perhaps we can pick a jury in the morning and then in the afternoon finish up.
I think I'd best make 2 judge days, but it'll be short.
Okay. We could probably send it to Impact.
February 12th.
Right, February 12th.
Judge, and can we hear his get a ruling on his motion to set bond?
Sure.
So, Your Honor, there's no bond set.
Just 1 second. Yeah. Let me get this written down. All right. Is there going to be any witnesses?
No, just my client if if it's necessary.
Okay.
Otherwise, I would just proceed by offer of proof unless the court wants my client under other parameter things I'm about to assert, Judge.
All right. Court is calling 2022 CR 10642, State of Texas. Well, let me ask you this. Have you conferred with the state on the bond and you all can't agree?
I did confer. I don't know if I got a disagreement necessarily. I just told him what I was going to ask for, so I don't know.
All right. Do you all want to confer to see if you all have an agreement on the bond? I still need to have a hearing on it, but if you all have an agreement.
I think we're probably going to want you to set it, Judge.
Okay. All right. State of Texas versus Jose Sanchez. Could I have parties re-announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense.
Eric Baker for Mr. Sanchez, Judge.
All right. And are you Jose Sanchez?
Sure.
All right. There's been a request for a bond reduction hearing. Is that correct, counsel?
Actually, Judge, the motion to set a bond.
Motion to set a bond?
Yeah.
No bond has been set?
No bond has been set, Your Honor.
All right. So are there any witnesses?
Your Honor, I'll call my client, but just I want to summarize for the court what we're going to be asking for and why. I've discussed with my client his finances and his ability to post bond. He is indigent. He has local ties to the community. He's lived here all his life. He was employed when he was arrested. He has that employment still available for him if he gets out. if the court sets a bond in the amount of $10,000.
Oh,
Sorry, Diana. My client's also being very helpful with the court, and it's a.
I'm gonna make note of that for the record, that he's helpful. Okay, you can continue.
And so we're asking to set a bond in the amount of $10,000 if the court's so inclined, and if not, as low as possible, if it sets it above $10,000. And I can put my, that's just an offer of proof. If the court wants me, I can put my client there open, asking those questions to establish those things if the court finds it necessary.
I'm sorry.
To establish those facts if the court finds it necessary. Advice, that's my offer of proof.
All right, state.
Yes, Your Honor, I would like to, I've showed this to defense, but this is the defendant's criminal history. I'd like to offer that as state's exhibit 1.
There's no objection.
Oh,
And then you can see from the criminal history judge and from the indictment that the defendant is a habitual offender judge. So the state does believe that based on his history, based on the facts of the case, that $10,000 is too low of a bond, Your Honor. He is looking at, because of his status as a habitual offender, he's looking at 15 years, Judge. So we're looking for a higher bond amount than what's been requested by defense. We are asking that if you were to grant a bond in this case, or when you grant a bond in this case, we're asking for a full house arrest GPS. The facts in this case are that the defendant is driving around without he knows he's not supposed to have a firearm, and he's got a gun in the car, Judge. So in order to protect the community, we ask you to take these, or take the GPS as a step to protect the community.
Can I respond?
Yes.
Number one, Your Honor, it was a felon in possession. It's not been established that he knew the firearm was there. That'll be established at trial. It wasn't a violent offense per se. Number two, Judge, he actually was out on bond on this case for almost a year. And then his bond's been dropped in because of the parole issue. So he's demonstrated he's not a flight risk.
so here's the court's question. Does he not have a bond because the bondsman issued an affidavit to surrender surety? Is that the reason?
Yes, Your Honor. Is the reason.
So before the bondsman did that, what was his bond set at?
He tells me 20,000. I haven't independently verified.
All right.
2022 CR 10642. Your Honor, I would ask the court to consider that although it was at 20, based on the 7 months he's been waiting for the state to answer a very simple question that it should have had the answer to in 1 week, I'd like the court to consider that in light of the fact that he may not be able to make a $20,000 bond, and in light of the fact that he's expressed a desire to get out so he can work, so he can afford his own attorney, he would like to hire an attorney. And secondarily, if the court is going to do GPS, I would request that the court allow him to work on that GPS monitor, because that's the main reason he wants to get out, so he can hire private counsel, and he'll need to do that quickly with a trial date in mid-February.
All right.
Judge, respectfully, can I respond to that?
Sure.
So the defendant claims he was on his way home from work when he had the gun. So, that's why we're asking for the GPS, Judge. It seems like he uses the gun for work sometimes. So if you are inclined to grant a bond, we ask for full house arrest GPS. If it is going to be partial, where he's allowed to go to work, we'd ask for set times, Judge. So it's not just like, oh yeah,
We'd have no objection to that. He could provide proof.
All right. So everybody it's whispering a little bit, which makes it difficult for the court reporter. So people are starting with their voice here, and then it immediately drops. So if everybody could keep their voice level for the court reporter, that would be greatly appreciated. Let's try to make her job as easy as possible.
And it's the state's
See,
fault.
Dinah?
I was just bringing it to his level.
Yeah. But Dinah, I'm always thinking of you. All right. So I have a question for you, sir. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
All right. You can lower your hand, state your name for the record, and keep your voice up.
Alfredo Sanchez Jr.
All right. So, have you ever used any type of drugs before?
Yes, ma'am.
And what would that be?
Methamphetamine.
All right. When's the methamphetamine, marijuana, anything else? All right, before you were taken into custody, when's the last time you used a drug?
7 years. I was locked up for 5. So I got out and I was out on for about a year and a half.
All right, have you ever had treatment for those issues before?
Have I ever had treatment?
Yes.
No, I've never been to a rehab. No, man.
Have you ever had any mental health issues?
Yes, I've been diagnosed with manic depression and drug-induced schizophrenia, and then I forget what the other one was.
All right, have you seen any type of doctors? Have you seen a psychiatrist or had a therapist?
The only thing I've done is here. I've done recovery and nursing, and in the world, I haven't done anything. I've never been offered that, so never done it.
All right. So the clerk has informed me that his bond before the bondsman got off his bond was $10,000.
Oh.
So unless there's some other reason for his bond being revoked, like for example, if he didn't show up for the court or something of that nature, I don't see why his bond shouldn't still be the $10,000. And that's based upon the fact that there was another judge who found that $10,000 was appropriate, and that's what they set it for. I would consider increasing his bond if there was a reason other than the bondsman joining an affidavit to surrender surety. But so I'm going to keep the bond at $10,000. I am going to order partial GPS. And that's for employment only. And you'll need to provide, your employment address. You need to provide what the hours you're working. You understand?
So I'm a member of the local 66 Iron Workers Union.
Mm-hmm.
So I show up there to the shop at 7:00 or by 7.
You'll need to give that to them.
Yeah, I'll get an itinerary.
And then I'm going to order outpatient treatment as a condition of probation. I'm sorry, as a condition of bond. I'm going to ask that the fees be waived. And I'm going to also order mental health treatment. And that will be waived fees on that. Although I don't think they have fees for that, but I'll just put that in there. All right. And I want you to know the reason why I ask the questions I ask, because legally we're supposed to do that so I can figure out what conditions to give you so that you'll be successful when you're on bond. You understand?
Yes, ma'am.
If there is something else that comes up where you feel you need more help with something, be it drug treatment or mental health treatment, let them know. If you feel like they're not addressing it, you can always come back to the court. All right, and we'll do random UAs.
My family already went and spoke to someone at Lifetime Recovery.
Okay. Well, I'm going to ask that the fees be waived, and if it's Lifetime Recovery that you can get into Lifetime Recovery, just have your attorney let the court know, and I can change these conditions to include Lifetime Recovery.
Thank you, ma'am.
All right. So, Norma, if you can give him a reset form for his case, and if you'll give this to the court reporter. Is there anything else from either side?
No, thank you so much, Judge.
All right. You're welcome. 2023 CR 10004, State versus Tyler Ashbaugh. Can our parties announce for the record for the state? Defense?
Nathaniel Navy for Mr. Ashbaugh.
And are you Mr. Ashbaugh?
Yes, Your Honor.
All right. Defense has filed a motion to amend conditions of bond. State, have you had a chance to review that?
I spoke with defense counsel about it.
All right. State, do you have any objections? All right. Defense, you may proceed.
Yes, Judge. So essentially, we would just be asking for two things. Number one is to amend Mr. Ashbaugh's current conditions from GPS full house arrest to GPS partial to allow him to work. And just a little bit of background behind that, Judge. We understand that the allegation is serious. However, Mr. Ashbaugh has been on GPS full house arrest for 2 years at this point. The case was pending an intake for quite a while. He has had no recorded violations of his GPS monitoring device. With Mr. Ashbaugh being on full GPS house arrest, he's had to live with his father to help support him. His father is older, in his 70s. He lives there with his wife and their daughter as well. This has placed not only a immense financial burden on Tyler and his wife, as they've had to move in with his father because Tyler can't work, but also on Tyler's father, who is now in his 70s, having to work extra and stress more about their finances. Tyler would like to have the ability to set up an interview and hopefully get hired somewhere and work to help contribute for his family, his children, his legal expenses, just to ease the burden not only on himself, but on his family as well, Judge. And as I've come in front of you before on another time on this case, I said, any little allowance you've given Tyler to do something, he's never abused the court's trust in this case since it's been pending on bond. And I think that will continue. He obviously takes this case very seriously. He takes his pretrial conditions of bond very seriously, as are evidence that he has had no violations since he's been on this monitor. The second thing that we would be asking for is the ability to go to, I forget the name of the hospital. What was that? Stone Oak Methodist Hospital, when his wife is due. She's due at the end of this month, but from talking to them, it may be sooner. Obviously, and I maybe seek the court's guidance as well with how to word this on GPS if you were to consider it and grant it, Judge. But for a one-time, and I don't know if it's to say tracking or one-time ability to go to the hospital, because it's going to be hard to schedule this. I think, just knowing from my experience, if I tried to schedule it, I think he would miss it. Or if he tried to schedule it, I think he would probably miss the birth. So just a one-time ability to go to this hospital, stay there until she's discharged, and then come home whenever that is. Obviously, pretrial services would have the address of the hospital ahead of time. He could even give them notice as he's about to go. But I think if he had to try to get permission and schedule it, he may miss it. But maybe if there was some way to say, it's either a one-time tracking ability where he's approved to go to this hospital at an unscheduled time for the birth and come home, go nowhere else but the hospital. That's what I would be seeking as well, Judge. And I know you've asked this before, so I've talked to him and his wife. They have had one other kid together. She said he was helpful. He didn't pass out. He wasn't just somebody who was actually a burden on her, but he did help. So she would like him there, Judge, if it's possible.
All right, so let's start with first. State, do you have any objections to him being allowed to attend the birth of his child at Stone Oak Methodist Hospital and to remain until discharge of wife and child?
No, Judge, just as long as it's pretrial and abides by the GPS.
All right, so that will be granted. Now, the next thing, with a request for him to be able to work while on GPS.
Judge, at this time, due to the allegations against the defendant, we were opposed to any other type of GPS other than full house arrest. Yeah.
Okay. All right. This is what the court is. The court will allow him to have employment. I don't know the nature of the alleged facts of the offense other than what I see that he's been charged with. So you will be allowed to, once you're employed, to work. But I know now that a lot of employment, the way you get interviews, is online. Am I correct in that assumption?
Yes, Your Honor.
Yes. I think the one that he's attempting to interview with, they do want you to come in person, right? It's with Kia World Car Mazda for a phone representative. They basically said, come in 9.
So here's the thing. If he is going to be working at a car dealership, I'm not going to allow him to be working at a dealership where he's driving around. So what would he be doing if he were to be hired? Yes.
Phone representative, ma'am.
All right. Could you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Tyler Ashwell.
All right, if you're hired, what is your position? What are your duties?
I'm not too sure necessarily, but it's a phone representative. I'm guessing I'll be taking phone calls about probably price inquiries and such things.
All right, and so will you be working from home or working at the dealership?
At the dealership, hopefully.
All right, so then what I'll do is I'll allow him to go to the interview. And when is this interview?
He told me just to come in from any time from 9 to 7, Monday through Saturday, and ask for Ed.
And you said Monday through Saturday?
Monday through Saturday.
All right, so I'm going to allow him to go to the interview. And you will need to schedule a time with them. And that time needs to be, state, I know you're not in agreement, but what hours? Because I'm not going to allow him to set his hour at 7 p.m. So it's going to have to be in the morning time. And what hours?
9 to 11.
All right, so he can set his appointment anywhere from 9 to 11. And I'll allow you 30 minutes beforehand to arrive and then 30 minutes to return. Is that enough time?
Yes, Your Honor. Yes, Judge.
All right, and you will need to let GPS know. Are you going to be there at 9, 10, or 11? Do you understand?
Yes, Your Honor.
All right, and then once he is employed, my mom always says, once you have the interview, usually they're going to hire you. So we'll come back if he is employed. Okay. And then counsel, if you just come in, if he ends up receiving the job and his duties are as he's telling me, I'll allow it.
Okay.
So, and I'm sorry, 9 to 11 a.m., you're going to have to get that appointment either Monday through Thursday, not Friday and Saturday. If there's some issue where they can only do it on a Saturday or only do it on a Friday, you need to come back and let the court know that's the plan.
Yes, Judge.
All right, is there anything else?
Just one other thing, Judge, because I know it's a possibility that he does the interview, they do the background check, they see that he's charged with this, and then they say no.
Mhm.
If there are other opportunities for job interviews, but this is the one that's immediate, if he has any other possible interviews, do we need to come in again, or is he okay to schedule interviews but just tell his pretrial services officer? How would the court like us to do that?
Well, to make it easier on everybody so people won't have to come down, counsel, if you want to include an email, include Mr. Gerhan in that email, your client in that email, and include me, of course.
Of course, Judge.
And you will put down where he is seeking to have an interview. And in each of those emails, I'm going to need to know what his proposed duties are if he's hired, because there are just some things that I'm not going to allow him to do.
Of course, Judge. Understood.
All right. Is there anything else?
Not at this time, Judge.
All right. And does everyone approve of the court's plan as far as if there are different interviews that can be asked through email?
Yes, absolutely, Judge.
Not opposed, Your Honor.
All right. Okay. Thank you.
Okay. Thank you, Judge. May we be excused?
Yes.
Thank you.
2024 CR 3321, State of Texas versus Carlos Gilbert Alamon. Can I have parties announced for the record for the state?
Allie Jackson.
Defense.
Patrick Hancock for Mr. Alleman.
Are you Mr. Alamon?
Yes, sir. Yes, ma'am.
Counsel, have you received all of the discovery? Did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Alamon, did you review the document entitled True Bill of Indictment with your attorney?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we are proceeding on count 2, which is waiving the rest.
Any objections to the waivers?
No objection, Your Honor.
Mr. Alamon, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged in count 2 with aggravated assault of a first-degree felony? Range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, The fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this agreement you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into an agreement in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, ma'am.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Alamon, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, state is proceeding on count 2. Punishment is to be assessed at 18 years in the prison. There's to be Chapter 62 compliance and no contact with the complainant. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Then to the offense in count 2, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
State offer states Exhibit 1 with all attachments.
No objection.
Did you review the document entitled Waiving Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Would you like to, Judge?
Anything you wish to say on behalf of your client?
Judge, Mr. Alderman has a few health issues. He's in need of a knee replacement. I put together his medicals as part of his legal papers, and I don't know if the court can make a recommendation that he have a medical assessment upon entering prison. I've seen some courts do it, and we would ask that you do it, Your Honor.
All right. Court will find you guilty, sentence you to 18 years in the prison, give you credit for any time served. There should be Chapter 62 compliance, no contact with the complainant, and I'll ask that you be provided with a medical assessment at the prison. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? And did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your
All
Honor.
right, thank you.
Judge finds Carlos Alam guilty and sentences him to 18 years in prison with credit for time served. Chapter 62. Compliance. No contact with the complainant.
Court is calling 2023 CR 8359, State of Texas versus Jose Diego. How do you pronounce that name? Amicus Zavala. Thank you. Could I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor. The attorney of record is Joanne De Hoyos. Joseph states who's standing in. And would you give this judge permission for me to do this plea in place of Ms. De Hoyos?
Yes. All right. We have an interpreter here. If you could raise your right hand. Do you solemnly swear or affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right. You can lower your hand if you'll state your name for the record.
Arlene Abrams, license number 2081.
All right. Mr. Amesquez, All of the documents I'm going to review with you are in English. Were those reviewed with you in Spanish?
See,
Yes.
And it's the court's understanding that Attorney Monica Guerrero went over the paperwork with him. Is that correct?
That is correct.
And she's fluent in Spanish?
She is.
All right. Counsel, have you received all of the discovery in this case, and was that reviewed with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Amesca Zavala, did you review and sign the document entitled Application for Community Supervision? With your attorney, did you understand it?
Yes.
Did you review the document entitled True Bill of Indictment? With your attorney, did you understand it?
see,
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Mr. Amescas Zavala, did you review the document entitled Court Admonishments and Defendant's Waivers of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
see,
Yes.
Did you understand you're charged with the offense of driving while intoxicated, third or more? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine.
see,
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
see,
Yes.
Did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent.
see,
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
see,
Yes.
And did you intend to give up those rights and enter into a plea in this case?
see,
Yes.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent or was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Zavala, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea bargain agreement?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
No.
Defense?
Your Honor, our client is not a U.S. citizen, as stated. He was able to retain the services of an immigration attorney. That attorney is named Mr. Eric Bernal. We had received a plea offer. We put a detailed description, email terms of the plea offer. Mr. Hoyos had spoke with him over the phone multiple times. There's numerous emails back and forth. Mr. Bernal recommended the plea offer that this particular one was actually favored, that Mr. Bernal preferred it. He will be deported. He understands that there's no promise that he could stay here legally. He does wish to have probation. We had discussed with him that technically a felony conviction is deportable by itself. But knowing this, he still wishes to go forward with the plea, and we have permission from his immigration attorney to follow this deal.
All right. Mr. Zavala, did you have ample opportunity to discuss with your immigration attorney the impact this plea bargain agreement would have on your immigration status?
Yes.
Right. Did your counsel advise you of the consequences of pleading no contest or guilty in this cause number and its impact on your immigration status?
Yes,
Did your attorney discuss with you possible consequences such as deportation, the denial of naturalization, or re-entry into the United States by entering into a plea in this case?
yes,
And do you understand the consequences of entering a plea in this case and the impact it will have on your immigration status?
Yes.
yes,
Counsel, do you believe your client understands the impact this plea will have on his immigration status?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Mr. Zavala, did you review the plea bargain agreement with the state? With your attorney, and did you understand it?
yes,
According to the plea bargain agreement, punishment is to be assessed at 7 years in the prison. There's a $500 fine. The state recommends community supervision. There is the VIP panel, ignition interlock for half the term, and a 2-year driver's license suspension. Did you understand that to be the plea?
yes,
State, is that the plea?
Yes, Your Honor.
Defense, is that the plea?
Yes, Your Honor.
Did you review the paragraph entitled waiver of appeal with your attorney? Did you understand it? And did you sign it in both places, Mr. Zavala?
yes,
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
yes,
Counsel, have there been any such motions?
No, Your Honor.
Did you review outside the agreement? The state is requesting that your community supervision be for a term of 7 years. There be a TAP evaluation, 120 hours community service restitution, 10 days house arrest in lieu of 10 days in the Bexar County Jail. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
yes,
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
no contest.
State, any evidence?
Your Honor, I offer State's Exhibit 1 in the attachments.
No objection, Your Honor.
Did you review the document entitled waiver and consent to stipulation of testimony and stipulation with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes,
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
yes,
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
yes,
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. After reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor, we waive PSI.
Anything you wish to say on behalf of your client?
Yes, I can follow the recommendation.
All right. Court will sentence you to 7 years in the prison, suspended and probated for 7 years. There's a $500 fine that will be probated. Victim Impact Panel, DWI intervention, DWI education, ignition interlock for half the term. I'm sorry, I started talking fast. 2 years driver's license suspension, 10 days in the Bear County Jail as a condition of probation, 120 hours of community service restitution, TAP evaluation in custody, follow recs, regular reporting by Zoom or in person, regular UAs, if deported, no illegal reentry into the United States. If he's not deported, then I'm going to want field visits 1 time per month for 3 months. And then it will be at probation's discretion. Proof of employment within 30 days. No employment as a home health care provider or with minors. Probation, is there anything else?
Ever say anything about UAs? Oh, yes, you did.
Okay.
Nothing else, Judge.
All right. Is there anything else you need from the court to be successful?
No.
All right. And do a gang evaluation, probation. All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal? Did you understand it and did you sign it?
Yes.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes.
All right, good luck to you. Thank you, counsel.
Thank you, Judge.
Court is calling 2023 CR 9821A, State of Texas versus Jason Jesus Guerra. Could I have parties announced for the record for the state?
Hank Wilkins with the state, Your Honor.
Defense?
Good afternoon, Judge. My name is Dirk Ashball. I represent Jason Gatto. We're ready.
Are you Jason Guerra?
Yes, ma'am.
Counsel, have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor, I have.
Court will find that the state is in compliance with discovery. Mr. Guerra, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading? I'm sorry. Y'all had enough time to confer?
It was somebody else, Judge, and they're not here, but he's okay.
Oh, no problem.
Yeah.
All right. I'm going to show you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, it appears that you're proceeding on the indictment as presented. Is that correct?
Yes, Your Honor.
Mr. Guerra, I'm going to show you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with the offense of theft, 2,500 to 30,000? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement you are giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Guerra, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $500 fine to be probated. State recommends deferred adjudication. This will run concurrent with County Court Cause number 714-096. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Judge.
State, is that the plea?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 4 years. There be a TAP evaluation, 60 hours of community service restitution, and CATs 1 and 2. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Contents.
State, any evidence?
Your Honor, I offer State's Exhibit 1 in the attachments.
No objection.
Mr. Guerra, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding you guilty as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Judge, I would like to let the court know that Mr. Guetta looks a lot better than he did the first time I met him in jail a few months ago. Since then, Judge, he's gone through a lifetime recovery program for about a month and a half. Completed a few other classes as part of that. He has definitely, I think, changed his mindset and is in front of you today, I think, with a positive attitude and kind of ready to make the most of this opportunity, Judge. I think he's sincere in that. And I have the certificates if the court would like to see, but
yes.
He is ready, Judge, I think, to take maybe this next step. He has had some problems in the past. Right now he's working. He is got a potential to pick up another job, a little bit better job, with more money, depending on what happens here, Judge, with this case. And he has another place to live. He's living with his, I think, his fiance, right? So his life is kind of moving to an upward trajectory, Judge, and I think this is a great opportunity for him to continue that. There's another opportunity for him to continue that. And that's just what I wanted to let the court know.
All right. Do you have employment?
Yes, ma'am.
What do you do?
Painting.
And your fiance, does she have any children?
No, ma'am.
Is she in recovery?
No, ma'am. She don't do drugs.
Okay. So how did you two meet?
In school. We were boyfriend and girlfriend in middle school.
All right. So how did you contact her?
I met her through her cousin. I found her through her cousin again.
So why were you searching for her?
I wasn't searching for her. We were, her cousin ended up at my house party at a party I was throwing, and I asked for her.
All right. So when was this house party? Was this before or after this?
2007.
Okay. And who is the person you were with during this theft? Are you still seeing them?
No, ma'am. I have no contact with that, sir. With that man.
All right. This is what the court is going to do. Court is going to sentence you. All right. 4 years deferred adjudication, $500 fine probated. This will be concurrent with 714-096, CATs 1 and 2, 100 hours of community service restitution, a TAP evaluation out of custody, follow recommendations of TAP, We'll start with intensive outpatient treatment if they're recommending treatment. There's to be no contact with Michael James Martinez. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Regular reporting by Zoom or in person. If you're drug tested today, what are the results going to be?
Clean.
For everything?
For everything, ma'am. Yes, ma'am.
All right. There's to be random UAs, random regular UAs, field visits, one time per month for 3 months, then at probation's discretion. And what are you doing to maintain your sobriety?
I'm currently going to a outpatient. I'm an appointment on December 27th. Due to lifetime recovery, I asked my counselor if she could enroll me in that. So that's the earliest appointment I could get. And I'm going to a counselor for Central Health Central Sources today. And what it is my counselor. We talk about my situations in life, what I'm doing, a couple of my abilities of drugs, and what I'm just doing in my life in reality. Everything going on in my life. And
all right. And this therapy is with who?
CHCS.
Okay.
It was getting into pretrial.
Okay. Probation. Is there anything else he needs?
No, Your Honor.
Is there anything else you need from the court to be successful?
No, ma'am. I just want to thank you for giving me the opportunity to be in lifetime recovery because it did help me and it made me realize my decisions and choices I was making were wrong and there's a better life without drugs.
Okay. Well, thank you very much. All right. And then we're going to have no contact with Target. And that's the Target that is located at 8223 State Highway 151. And he's to continue with therapy with lifetime recovery and counseling with Center for Healthcare Services. All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And did I mention cats 1 and 2?
Yes.
All right, thank you. Thank you.
Merry Christmas, ma'am.
Oh, Merry Christmas to you. Happy New Year. Happy Festivus. Happy Kwanzaa. Happy holidays.
Thanks. Have a good day.
All right, you too.
And just like that, the hearing came to an end. In the courtroom, second chances aren't given because of promises, they're earned through actions. What happened here is a reminder that every decision has consequences, and eventually those choices catch up with you. Let us know in the comments, do you think the judge made the right call?